This presentation will provide an overview of the Immigration Services Act and regulations. On July 1, 2024, the Immigration Services Act was enacted to replace previous legislation called the Foreign Worker Recruitment and Immigration Services Act, or FRISA. The new legislation aims to accomplish the following: strengthen Saskatchewan's immigration integrity framework through stronger investigative authorities and enforcement measures to deter and address immigration fraud, increase transparency and accountability for foreign worker recruiters, immigration consultants, and employers, and provide new authority for settlement and immigration programs and services. With growing demand for immigration in Saskatchewan and increasing numbers of employers using the Saskatchewan Immigrant Nominee Program, there's an increased risk of fraud and program abuse. As a result, the Ministry of Immigration and Career Training developed the new Immigration Services Act and regulations. The new Act and regulations improve the province's ability to support newcomers and establish the most robust program integrity framework in Canada. It allows the province to provide increased support to newcomers, from pre-arrival resources to long-term assistance, to ensure Saskatchewan can retain this population. Some key provisions that existed under the FRISA, the previous legislation, have been retained in the Immigration Services Act. This includes, employers must pay all recruitment costs. These cannot be charged to or recruit from the worker. Foreign workers cannot be charged money for a job offer, an SINP job approval letter, or a labor market impact assessment under the Temporary Foreign Worker Program. A license is required in order to provide immigration and/or recruitment services. Immigration applicants cannot be forced to use a consultant or recruiter. In order to recruit and employ foreign workers through federal or provincial immigration pathways, Saskatchewan employers must hold a valid certificate of registration. The new Act brings about increased investigative authority and enforcement measures to tackle immigration fraud. Maximum fine amounts have been increased to $750,000 for individuals and $1,250,000 for corporations. Additionally, authority has been expanded to provide enforcement staff with peace officer status to conduct inspections and investigations. This allows staff to attain a search warrant and production order. The Act provides new authority for the Ministry to prescribe administrative penalties in the regulations. Administrative penalties will be used for situations where court charges are not required, for example, in cases of minor non-compliance issues. The new maximum administrative penalties are $200,000 for individuals and $400,000 for corporations. Through the Immigration Services Act, new fees have been introduced as well. There are new application fees for a foreign worker recruiter or immigration consultant license. The fee is $300 for a new license and $50 for renewal, which is required every 2 years. The Saskatchewan Immigrant Nominee Program Human Capital application fee has been increased to $500 from $350. And lastly, a new fee for the Saskatchewan Immigrant Nominee Program's second review process has been introduced. It will cost 50% of the initial application fee to request a review of an application that was deemed ineligible, which is $250 for human capital applicants and $1,250 for entrepreneurs. Fees and penalties support stronger program integrity and encourage compliance with the Immigration Services Act and regulations. The new authorities outlined will increase program integrity and further protect foreign workers from exploitation through several means. The Act increases transparency and accountability for foreign worker recruiters, immigration consultants, and employers. The new regulations introduce a new code of conduct for registered employers and strengthen the code of conduct for licensed immigration representatives. Introduces new requirements for businesses to provide proof of financial capacity and stability when recruiting international workers. There is an expansion of the list of offenses. For example, it now includes counseling others to commit offenses. The measures expand the authority to suspend or cancel a license or registration based on non-compliance with the Act and regulations. There are new provisions that clarify that an individual's license does not extend to employees, which will improve the oversight of foreign worker recruiters and immigration consultants. The Ministry can refuse an application for a license or certificate of registration if the applicant has a confirmed relationship with a non-compliant individual. Requires disclosure of partners, affiliates, agents to the director and clarifies the accountability of licensees and registered employers for activities conducted by partners, affiliates, or agents. The most critical piece of this legislation is ensuring that newcomers are protected while they use a safe and ethical immigration system. There will be a new process for persons to file a complaint related to the Act to the Ministry with source privilege to safeguard the identities of complainants. The identity of a complainant will not be disclosed without the prior written consent of the complainant. Meanwhile, it prohibits situations in which foreign worker recruiters, immigration consultants, or employers use any information, documentation, or decisions provided for or by a selection program as leverage for financial gain. Compensation will be provided to workers in situations where an employer received payment from a foreign worker for a job offer or approval or support for an immigration program. In terms of information sharing tools, the Act allows the Ministry to publish a registry of employers on our website, so newcomers know if their employer or potential employer has registered and met the requirements, likewise for immigration consultants and recruiters. The Ministry also has authority to publish any violations of the legislation, regulations, or codes of conduct by licensees or employers. Increased collaboration and information sharing between immigration and enforcement agencies will be constructive in combating immigration fraud and labor exploitation. Lastly, the legislation expands the Ministry of Immigration and Career Training's authority to provide a full suite of comprehensive settlement services for newcomers. Currently, settlement services are primarily focused on support post-arrival. Consequently, this legislation will provide the government with authority to expand services offered to newcomers immigrating to and settling in Saskatchewan, beginning at the pre-arrival stage. Access to pre-arrival services may enhance retention by helping immigrants to build a successful social, cultural, and economic life in Saskatchewan. Overall, the new legislation enhances integrity measures, making the immigration system in Saskatchewan safer and more attractive to newcomers. If you have any questions or require additional information, please email us at the email address on the screen.